Attention, we are live in 3, 2, 1.
Good morning and welcome to the December 13th, 2021 Land Use Hearing Officer meeting. I'm Pamela Jo Hatley. I'll be the hearing officer for today. Before we get started, if you can stand, please, if you're able, for the Pledge of Allegiance. All right, thank you. Again, I'm Pamela Jo Hatley, and I'll be the hearing officer this morning. Again, if you didn't hear the announcements, if you have any devices that make noise, please silence those at this time. And first we'll have Mr. Okay.
Excuse me, Rosa, can you please mute your mic?
Thank you. All right. Mr. Tom Hisney of the Hillsborough County Development Services Department will introduce staff and agenda changes.
Good morning, all. I'm Tom Hisney with Hillsborough County Development Services. To my left is Carmen Mason. She is also with Development Services staff. During the course of the meeting, we will be joined by various staff planners from Development Services on the various cases. They will be joining us virtually. We will also be joined virtually by County Attorney staff Cameron Clark and Mary Dorman.
All right. Thank you, Mr. Hisney. All right. So before we go further, I'd like to just read off some meeting procedures for this morning. First of all, the agenda consists of items that require a public hearing by a hearing master. I will conduct a hearing on each item today and will render a decision within 15 working days after the conclusion of today's public hearing. My decision will be filed with the clerk of the Board of County Commissioners. The hearings today will be informal. I will ask questions related to the scope of direct testimony and may call and question witnesses as I deem appropriate. I will decide all questions of procedure. I will take evidence, but will exclude evidence that is irrelevant, immaterial, or unduly repetitious. Evidence may be presented in written form, and all testimony shall be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding of fact unless it would be admissible over objections in a civil court action. The order of presentation will be as follows. First of all, for variances, Mr. Hisney will call the case. Then County Development Services will have 5 minutes to present its report and findings. Then the applicant and the applicant's witnesses will have 15 minutes to present the proposal. And then proponents will have 15 minutes to present arguments in support of the proposal. And opponents will have 15 minutes to present arguments against the proposal. County staff will then have 5 minutes to present any amended findings or comments. And the applicant will have 5 minutes for rebuttal and summation. For the special use cases, Mr. Hisney will call the case. Then the applicant and the applicant's witnesses will have 15 minutes to present the proposal. County Development Services will have 5 minutes to present its report and findings. Planning Commission will have 5 minutes to present its findings of compliance or non-compliance with a comprehensive plan. Proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against the proposal. And then county staff will have 5 minutes to present amended findings or comments. And the applicant will have 5 minutes for rebuttal and summation. The 15 minutes that are allotted to proponents or opponents is the total time allotted among the speakers. So if there are a number of persons who wish to speak, the 15 minutes will be distributed among you. If you would wish to designate a single spokesperson to represent your views, you may do that. When you come to the microphone to speak, first, please state your name and address for the record. The meeting is being recorded. Please speak into the microphone so your testimony can be recorded. And when you're finished speaking, please see the clerk to my right here to sign in. All right, now we'll hear from the county attorney's office who will explain the legal requirements for procedures or appeal.
Thank you, Madam Hearing Officer. Cameron Clark, Assistant County Attorney. This land use hearing officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed a case, the record of that case is also closed, and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony that is presented at this public hearing shall be the only evidence that is subject to review by the Appeals Board. In reaching a final decision on petitions, the Appeals Board will only consider the decision of the hearing officer and the record that is made at today's public hearing. If an appeal is filed, the Appeals Board hearing shall consist of oral argument by the party appealing the decision, by county staff, and by any interveners, each of whom may be represented by legal counsel. The following shall stand to appeal a decision of the hearing officer or intervene in an appeal. First is the applicant. Second is anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It is the role of the County Attorney's Office to ensure that no new evidence or testimony is allowed before the Appeals Board that was not presented to the hearing officer at today's hearing. The County Attorney will recommend that the Appeals Board disregard evidence or testimony that is outside the record made at today's hearing. Any evidence presented to the Appeals Board that is outside the record created at today's hearing could jeopardize the legality of the Appeals Board decision, and the presenter of that evidence could hurt his or her own cause. The safest course of action then is for you to write down any comments that you make today and to repeat those comments to the Appeals Board. Thank you.
Thank you, Mr. Clark. All right, so all testimony today must be made under oath. If you plan to speak, please stand if you're able, raise your right hand, and I will swear you in. Anyone online who wishes to speak virtually, please also raise your hand to be sworn in. All right. Do you swear or affirm the testimony you are about to give is the truth, the whole truth, and nothing but the truth? Thank you. All right, Mr. Hisney.
All right, so first I'm going to read in some changes to the agenda. Agenda page 6, item H3, Variance Application 22-0016, applicant Diana Street Partners, LLC. This application has been withdrawn by the petitioner. Second change is agenda page 6, item H5, variance 22-0068. The applicants are Brent and Kelly Blankenship. This application is a conservation area setback variance request and will be heard as item F1 in the site development variance request sections of the agenda. I'll now read into the record our published withdrawals and continuances. Item A1, variance 21-1248. The applicant is Mariadel Perez and Guillermo Del Rio. This application is out of order to be heard and is being continued to the January 24th, 2022 Land Use Hearing Officer meeting. Item A2, special use application 21-1344. The applicant is Crown Castle USA. This application is out of order to be heard and is being continued to the March 21st, 2022 Land Use Hearing Officer meeting. Item A3, variance application 21-1372. The applicant is Alliance Realty Partners, LLC. This application is out of order to be heard and is being continued to the February 21st, 2022 Land Use Hearing Officer meeting. Item A4, variance application 22-0009. The applicant is Annie Mintz Simmons. This application is out of order to be heard and is being continued to the January 24th, 2022 Land Use Hearing Officer meeting. Item A5, special use application 22-0027. The applicant is Mocha Asian Cuisine. This application is being continued by the applicant to the January 24th, 2022 Land Use Hearing Officer meeting. Application A6, special use 22-0063. The applicant is SRJ Restaurants Incorporated. This application is out of order to be heard and is being continued to the January 24th, 2022 Land Use Hearing Officer meeting. Item A7, variance application 22-0065. The applicant is Donna and Paula Riley. This application is out of order to be heard and is being continued to the January 24th, 2022 Land Use Hearing Officer meeting. Item AA, variance application 22-0079. The applicant is John Saldana. This application is out of order to be heard and is being continued to the January 24th, 2022 Land Use Hearing Officer meeting. Item A9, special use application 22-0082, Ross Investment Group of Tampa. This application has been withdrawn by the applicant. And let me just restate in case I gave the wrong dates. Item A2, special use 21-1344 is being continued to March 21st, 2022. And variance application 21-1372, which is item A3, is being continued to February 21st, 2022. And that concludes the published changes and withdrawals.
Thank you, Mr. Hisney. All right. I believe we're ready to call the first case.
Okay. We have no vested rights cases today, no fee waivers, no remands, and no reconsideration requests. Oh, I'm sorry. We have one reconsideration request. That is item E1, application, variance application 21-0914. The applicant is Ronald Fair. They are requesting a sign variance. Staff findings will be presented by Kim King.
Good morning. Would you like me to read the report into the record?
Yes, Ms. King, thank you.
Okay. This variance application was heard at the August 23rd, 2021 Land Use Hearing Officer meeting. The hearing officer denied the variance on September 13th, 2021. The applicant then sought a reconsideration of the matter as provided by LDC section 10.02.03I, and the hearing officer granted the request for a rehearing on the application. The applicant is requesting a variance for additional square footage and height for a pole sign located at 1616 Allison Woods Lane. Per section 7.03.00 B, 2, A, and B of the Land Development Code allows this parcel to have two signs at 50 square feet per side, 100 square feet total, or one pole sign at 100 square feet per side, 200 square feet total, based on the street frontage shown on the site plan. Per section 7.03.00 C1A, no ground sign shall exceed 30 feet in height if located adjacent to an expressway or arterial highway. The first variance, the applicant is requesting an additional 376 square feet of sign area, which would allow 576 square feet total for the proposed pole sign. The second variance, the applicant is requesting an additional 52 feet, 4 inches of height, for a total of 82 feet, 4 inches in height. And that concludes the report.
Thank you, Ms. King. All right, we'll hear from the applicant.
Morning, Ms. Harley. Long time no see. How are you? I'm Paul Elliott, and with me today is attorney Fred Mills. I'm an attorney here in Tampa, Florida, and I am also being permitted to speak on behalf of Mr. Ron Fair, who's also present, along with George Padilla, his company engineer. Fred and I might both be talking. I think what happened, you granted this matter for reconsideration due to inadvertence or mistake, and apparently,
Mr. Elliott, can you just pause one moment, please? I have a question for Mr. Hisney. Was there a question about the applicant's agent? Okay. Thank you. So the authorized agent, all right, Mr. Padilla, please come forward and state your name and address on the record and state that the speakers are authorized by you.
Yes. My name is George Padilla. Address 1616 Allison Woods Lane, Tampa, Florida, 33619. And I'm allowing Mr. Mills and Mr. Elliott to represent Mr. Fair, the owner of the property.
All right.
Okay.
All right. Thank you very much.
Okay.
And please see the clerk to sign in.
Yes.
Thank you. Thank you, Mr. Elliott. Please proceed.
If I recall correctly, your order indicated that there were some issues, and one of them that was particularly important was that the fact that the petitioner did not own the property that the sign was going to be on or have any particular legal rights to do that. I'm not sure, but I do have a commercial billboard signage easement agreement that was prepared by Mr. Mills between the property owner at the time that this property was conveyed by Mr. Fair's company, and it is an easement for the corner that this sign is going to be on. And I don't know whether it's been admitted into evidence, but if it's not, I'd like to submit it into evidence at this particular time to show you that the petitioner, which is actually Mr. Fair's company, has the legal right by virtue of this lease agreement that Mr. Mills prepared to have a sign on the property titled in the name of the other, what was the name of that other company? ADR, something like that. So how do I get this to you?
All right. Would you please submit that to the clerk's office? And I will see it and review it.
Okay, so that is the document that entitles Mr. Fair's company the right to put the sign on this particular piece of land.
All right. And that is a private agreement between those two property owners, correct?
Yes, ma'am, and it is recorded with the clerk's office, so it's on public record.
Okay. And question for you. In the application for this variance, which property was indicated?
I believe that my client's property was indicated as the owner of the property. What is it? RAF Land Development.
And the sign is physically not going to go on that particular parcel. Is that correct?
That parcel is not the title owner of the property where the sign is going to be put, but RAF has that lease agreement with the title owner of the property to put a sign on that property.
Thank you. And I do recall reviewing the survey and also the plat, and I'm familiar with the two properties. I believe it's parcel C on the plat.
Yes, ma'am.
Okay.
Mr. Padilla has a diagram that I'd like to submit to you, which shows the little yellow part is where the sign's going to be. The lighter part is the darker part is the owner of the property, the petitioner, and the lighter part is the owner of the land that the sign's going to be on.
Thank you. And you may submit that also to the clerk if you would please, and I'll certainly review it.
Okay, we have another amendment to this petition. We're going to withdraw the height petition. It was originally submitted due to the fact that in the right-of-way along I-75, there were very tall trees. They have all been removed. Mr. Fair got permission to remove them all, and now it's just grassy areas along the right-of-way. So we don't need the height variance anymore, and we will be able to comply with the 30-foot maximum height requirements per the regs.
Okay, then just to clarify, you are not requesting a height variance at all. Is that correct?
Correct.
Okay. And so the request, the variance request that I'm to consider is simply for the sign area square footage.
Yes, ma'am.
Thank you. I still have questions about the parcel where the sign is going to be physically located.
Okay.
The owner of that parcel, did they sign anything on the application? Did they authorize anything in this record for me to grant a variance that affects that land?
What I can recall, they signed this?
Yes.
Yes, ma'am. There's a letter here from the representative and owners of that property that we'll submit into evidence. Addressed to Ms. Hartley? So they're in agreement with this. The sequence of titling in this thing, for your information, is that Mr. Fair's company conveyed the property to another entity, and that entity conveyed it to the current owner, subject to this lease, billboard lease agreement,
Okay.
or easement agreement, excuse me.
Okay. Then I will certainly review that letter. I guess the outlying issue that I still have, and maybe I need to hear from the county attorney's office on this question, is whether the land use hearing officer can grant a variance on a parcel of land when the owner of that parcel of land didn't submit the application, and that parcel is not indicated in the application, and that parcel owner hasn't authorized any agent to request a variance be granted on that affects that land. That's the question I have.
Madam Hearing
Well, if
Officer
we-
Cameron Clark, Assistant County Attorney. Can you hear me?
Yes.
Okay. So you can, your review is going to be limited to the application, and the application has to be limited to the property that's owned by the applicant. So you're talking about basically the four corners of the lot. They're asking for a variance to certain land development regulations, and you can only grant a variance within the area where the applicant actually has the authority to apply for it.
So Mr. Clark, if the variance then is affecting a parcel that the applicant does not own, should the applicant have been the owner of the parcel that's actually affected?
Well, variances invariably are going to affect neighboring properties. I mean, setback encroachment is going to affect, for instance, neighboring properties. But if it's actually making some sort of a physical change to the regulations that apply to an owner that is not applying for the variance, that has not requested a variance to land development regulations, then you're constrained to the variance before you as it is affecting the property of the owner that applied for it.
I'm not sure I understood anything that he said, Ms. Hartley.
All right. Thank you, Mr. Clark. I understand you. So, Mr. Elliott, the application listed the parcel that is owned by Mr. Fair's company. And when I review that application, then I review it as that parcel owner requesting a variance affecting that parcel. But the problem I have here is that that parcel is not where the sign is going. The sign is going on a different parcel. And I do understand the private agreement between you, but the owner of that parcel where the sign will be going, where the variance will be affecting, is not the applicant, has not signed the application, and has not authorized an agent to request a variance affecting that owner's property.
Well, in that particular case, then, might it be appropriate for us to ask you to continue this matter a little bit for us to get this property owner to join into this petition? Because we can definitely do that if we're given the time to do it and not have to go through a whole new repetitioning process. Because we can get the owner of the subject parcel to join into this petition.
Did you wish to speak, Mr.?
Yes, and the owner,
And state your name and address for the record, please.
I apologize. My name is Fred Mills. I work with the firm of Morrison and Mills. It's 1200 West Platte Street, Suite 100, Tampa, Florida, 33606. So the owner of record of Parcel C, which has been identified, is a company called DBK Real Estate Holdings. The actual owner is on a 2-week vacay, so he could not be here. He apologizes. He can't attend. He signed the letter, but Mr. Fair and I spoke on Friday. I had 15, 16 years ago, I wrote that easement. Mr. Fair, when he and Mr. Padilla submitted, they were under the impression that they owned the property, that I had retained that. So I had to explain, and we walked through it, that we had actually deeded it out in fee simple and then received back the easement across the property. The easement agreement does anticipate that they have the right to file for the signage and everything else. I read your decision. I explained to them, I believe that parcel C needs to be a co-applicant simply because it's a permanent change. And yes, it's within their box, within their easement. And so as I explained it to them, he said, okay, so I don't own it. You don't own it. So when I wrote subject property, it's not on the subject property. I said, no, it's not. It's on the parcel C. So he understands, I understand. And part of the clarification in what we're offering today is there were changed circumstances, which you've heard about. So the height's not needed. Their DBK Real Estate Holdings is willing to participate. They could not do so on the short notice. If they were a participant, you would then have A and C, both parties to that private agreement. So you're not going to be asked who's on first, what's on second, who has what rights. You're just basically stating, or you would, if you would grant us the continuous, be able to hear from both and see that there is a joint opinion that they would like for this to be considered by you, both as the owners.
All right. Thank you so much for explaining that. I do understand. And would you please sign in with the clerk? And then I think I just should ask the applicant to confirm on the record that you're requesting a continuance, and when do you want the continuance to? What future date?
Let me rephrase the way we might approach this thing. If we can just get the other property owner, the original property owner, to sign a document and submit it into the record, rather than have a physical hearing set like today, that would be much better. And then you can go ahead and make a decision on what we've talked about here today.
No, there has to be a hearing. It has to
A hearing?
be. Yes, sir.
And then, do they have to show up?
They can authorize an agent.
Okay. If there has to be a hearing, we'll be happy to comply with that and appreciate it. I don't think there's anything. Is there anything else? Ron, you wanted to, want you to come up here and.
Ronald Fair, AEC, as well as RAF Land Development, 1616 Allison Woods Lane, Tampa, Florida, 33619. The party is also in agreement. I can only apologize that we didn't make some of this stuff clear. I had to be out of town when all this got done. But again, if there's any way that we could do it without being further delayed, we've already had to do 2 notices already on this. So it's been a little painful on our side, but if there's any way that we could do it, like I said, I think it's pretty clear cut. I don't think there's plenty of signs up and down I-75, which we can also put into evidence that we're not asking for anything that precedence already hasn't been set. And therefore, at this point, we're really just cleaning up some details on ownership, in my opinion.
And there's no opposition.
Madam Hearing Officer, being how this case has been open today for hearing, it can be continued to another hearing date without need for renotice by the applicant, because the hearing actually started today. They just need to pick what hearing they would prefer. I guess it's also connected to your schedule or your availability. The hearing dates, next 3 is January 24th, February 21st, and March 21st.
January.
Yeah, first available.
First available.
And that'll be at 1:30 p.m. I'm sorry, 10 a.m. Excuse me, 10 a.m.
10 a.m., correct. And then, Madam Hearing Officer, of course, that's also subject to your availability on that date.
1 second.
January 22nd.
No, 24th, sir.
Time again.
10 a.m.
Thank you.
Well, that's when the meeting starts, when your case comes up is where it falls on the
Yeah.
agenda.
God only knows. Thank you.
Okay. So we're requesting a continuance to January 24th, 2022 at 10 a.m. Land Use Hearing Officers Meeting. Do I need to ask for proponents and opponents? I mean, this is a...
Ask county.
Okay.
As county attorney, I'm not sure.
County Attorney's Office. Do we need to proceed and ask for proponents and opponents input this morning?
Madam Harris, this was a notice hearing this morning, and it's being moved to another date without a new notice. I think it'd be best to go ahead and check that at this time.
Thank you so much. All right, Mr. Elliott, if you would please sign in with the clerk's office. And we have to go through the rest of the process for the hearing. And there was another document that you wished to submit, I believe?
Yes. These are just some additional other variances that have been approved, very similar to what we're asking for. So we just want information for you when you're doing your review.
All right, submit those with the clerk's office now, please. All right, is there anyone here or online who wishes to speak to this application as a proponent in support of this application? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? Okay, don't hear anyone. All right. So this is variance 21-0914. It is being continued to the January 24th, 2022 Land Use Hearing Officer meeting, 10 o'clock a.m. And that will close the hearing on this item. Mr. Hisney?
Okay, that then takes us to section F of our agenda, which are site development variances. We have one case, variance application 22-0068. The applicant is Brent and Kelly Blankenship. The request is for a wetland setback variance. Staff findings will be presented by Carla Shelton.
Good morning. This is Carla Shelton Knight with Development Services. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on November 12th, 2021, is to allow for the replacement of an existing fence within the 30-foot wetland conservation area setback. Summary, item number 1, per Land Development Code, section 4.01.07B4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests construction of a new fence within the 30-foot wetland conservation area setback that will replace an existing fence in the same location. The applicant requests a 28.8-foot reduction of the setback to allow for a setback of 1.2 feet. Item 2, the existing pool and screen enclosure built in 2000 also encroach into the 30-foot wetland setback area. There were no variance approval documents found for the encroachment of these items, so the applicant is also requesting an after-the-fact variance for the encroachment of the existing pool and screen enclosure into the 30-foot wetland setback. The applicant requests a 5-foot reduction of the setback to allow for a setback of 25 feet for the existing pool and screen enclosure. That concludes staff report.
Thank you, Ms. Shelton. All right, applicant?
Hello, my name is Kelly Blankenship. Our address is 12808 Royal George Avenue, Odessa, Florida, 33556. We bought this house in 2019. And when we bought this house, the pool structure was already there and there was already an existing fence there. We live in the Eagles, which has a very strong HOA. So one would think that since the fence was already there, it had prior HOA approval. It's a wooden fence. We're simply just trying to update it to a vinyl siding fence and then an aluminum rotted fence across the back where the conservation area is. When we had the fencing company come out, give us a quote, we submitted the plans to the HOA, and then that's when they noticed, like, you never had permission to have this fence there to begin with. So that's when we started this variance project. So like I said, the fence is already there. We're not trying to change the location of the fence. We're just simply trying to upgrade the fence. And then as far as the pool goes, it was the same thing. The pool was built in 2000, and we just found out through this whole process that we needed to get a variance for the pool structure that's already there. And
Okay.
I believe, I'm sorry, I'm no expert on this matter by any means, but when the pool structure was built, it's to my understanding that the pool stopped at the 30-foot line so that it actually didn't encroach into the setback, but then that the setback line shifts over the years. And so when they just came out this past summer and looked at where that line was, it had moved into so that the pool structure was encroaching. But when it was originally built, if you look at the first property survey, you'll see that to begin with, the pool didn't encroach on that setback.
Do you have that survey? Did you submit that?
Yes, ma'am.
Okay, so that original survey is in the file. I can see
Yes.
it. Okay.
Yeah.
All right. And so I understand you're not building any new structures. You're replacing an existing fence.
Correct.
And you're just getting an approval for the existing pool that structure that's there.
Yes, ma'am.
Okay, good. Anything else you have to add? All right. Thank you. Please see the clerk to sign in. All right. Is there anyone here or online who wishes to speak in support of this application? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right. Don't hear anyone. County Development Services, any amended recommendations or anything further?
Nothing further from staff.
All right. Thank you. And applicant, you're entitled to 5 minutes for rebuttal and summation. Did you have anything else you wanted to add? No, that's a no. Thank you. All right, so this will close the hearing on variance 22-0068.
We have no new sign variances, so that takes us then to section H of the agenda, which is the general variances. First case is item H1, application 21-0902. The applicant is David Wright. The request is a variance to lot development standards and also a variance to encroach into a wetland conservation area setback. Staff findings will be presented by Tanya Chapella. Also, Carla Shelton will be on hand to answer any questions about the conservation area setback variance.
All right. All right, was that Development Services?
Tanya? We have a connection problem, communications?
Tanya, this is Glenn with Communications. Can you hear me?
She was having audio issues. She's signing in.
Yeah, I'm so sorry.
Go ahead.
Good morning, Tanya Chapella, Development Services. The applicant is requesting a variance for proposed front porch addition to a single-family home on property zone RS6. Additionally, the applicant seeks 3 variances for an existing setback encroachment for the home and existing wetland setback encroachments in the rear yard. The first request is for the existing home. Per the Land Development Code, Section 60101, the required minimum from setback for property zone RS6 is 25 feet. The applicant requests a 3.5-foot reduction to the required front yard setback to allow a setback of 21.5 feet. The second request is for a proposed front porch. For the Land Development Code, Section 60103, front porches, which comply with certain design and dimensional requirements, may intrude no more than 10 feet into the required front yard. The required minimum front yard setback for the subject property is 25 feet. Therefore, a minimum setback of 15 feet is required for the front porch. The applicant requests a 0.2-foot reduction to the required front yard setback to allow a setback of 14.8 feet from the front property line. Finally, there is a request to wetland setback requirements per the Land Development Code, Section 40107, no filing, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests after-the-fact approval for the existing stone walkway, concrete patio, brick patio, and fire pit located within the 30-foot wetland conservation area setback. The applicant requests a 27.9-foot reduction of the setback to allow for a setback of 2.1 feet. This concludes my presentation. I'm glad to answer any questions.
Thank you, Ms. Chapello. All right, applicant.
Good morning. I'm online. Good morning, Madam Hearing Officer. My name is David Wright. I'm the president of TSP Companies, and our address is P.O. Box 273417, Tampa, Florida 33688. I have been sworn in.
Okay.
We are requesting 2 variances for conditions that existed when the property owners purchased the subject property in 2012 in order to bring the property into conformance with the Land Development Code. Both of the conditions were discovered when the property owner attended a pre-application meeting with county staff prior to submitting an application for a building permit for minor renovations to the house. The first request is to allow an encroachment into the wetland conservation area setback. The existing encroachment is a retaining wall, stone pathway, brick seating area, and fire pit, which are depicted on the site plan. As previously mentioned, this encroachment was constructed by a previous property owner sometime prior to 2012. The area of the encroachment measures 520 square feet, and the property owner is proposing 520 square feet of wetland plantings within the wetland setback area in order to compensate for the encroachment. The next request is to reduce the front setback from the required 25 feet to 21.5 feet. The house was originally constructed in 1968 and is located on a cul-de-sac. No modifications to the front facade of the residence have occurred since the original construction. Therefore, we believe the original construction was subject to a different land development code than the current code, resulting in the nonconformity that exists today. The property owner is seeking this variance to bring the property into conformance with the current land development code. We had also included the request to LDC 6.0103I7 related to the covered entry. However, county staff determined that request is not necessary. The variance criteria and responses are already part of the record for this application, so I will not read those in the interest of time. We prepared a thorough and professional application package in compliance with the county's land development code. We noticed the surrounding property owners in accordance with the county's public notice requirements. We have not been contacted by any citizens who object to the requested variances. Further, there are letters of support from surrounding property owners in the record and no objections from any parties of record. I'm requesting your approval of variance application 21-0902, and I'm questions.
Thank you very much. I don't have any questions for you right now. All right, we'll go to proponents. Is there anyone here or online who wishes to speak in support of this application? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, don't hear anyone. Development Services, anything further?
No, ma'am, nothing further.
All right. Applicant, and I just want to clarify, so your request is for front porch setback, and that's just 0.2 feet reduction to the setback. Is that correct?
No, that's not correct. It is for front yard setback.
Yeah, I misspoke.
Okay. Go ahead. It's it's a reduction of the front yard setback from 25 feet to 21.5 feet, and also a reduction of the wetland setback to 2.1 feet. So there's two requests.
Yeah, Madam Hearing Officer. Yeah, with regards to the front yard setback, there's the setback for the existing home encroachment into the front yard, and that requirement is 25 feet. However, for the proposed front porch, the Land Development Code does provide for a 10-foot reduction to the required front setback for porches which meet certain dimensional and design requirements. And this porch meets those dimensional design requirements. So the required setback for the front porch is actually 15 feet because of the provisions of section 60103I7. And so they're asking for a 14.8 foot setback reduction for the front porch because, again, the applicable setback is not 25 feet, it is 15 feet because based on the elevations and if they submit it, and I'll have Tanya confirm this, that the proposed porch meets the design and dimensional requirements of the code to allow a 10-foot reduction in the setback, and also for the applicant to confirm that.
Yes, the front porch is bigger than it is required by the code, by 6.
And then also, and for the applicant, the front porch is open on all sides other than perhaps railings, correct?
That is correct.
Right. Okay. So then the required setback for the front porch is 15 feet because of the allowance in that section of the code that's identified in the report.
Okay, so let me make sure I understand because I'm reading this from the staff report. Minimum setback of 15 feet is required for the front porch. The applicant requests a 0.2 foot reduction to the required front setback to allow a setback of 14.8 feet from the property line. Is that correct for the front porch?
I'd have the applicant confirm that dimension, please, that setback.
Applicant, do you need me to read that again?
No, I'm looking at the site plan. Just a minute.
Okay, thank you.
Yes, that is correct. We are requesting a 0.2 foot reduction in the setback to the front porch.
Okay, thank you. And then the existing home, the request is for a 3.5 foot reduction to the required front yard setback for the home.
Correct.
Okay. And I think I understand the other one for the wetland setback. And the existing home, of course, and the backyard improvements, those were all existing when your client purchased the home. Is that correct?
Correct. They purchased the property in 2012, and those were existing at that time.
All right. And so the only thing they're adding then is the front porch.
Correct.
Okay.
There will be improvements on the back of the house, but they do not encroach into any setbacks.
Thank you. Did you have anything further you wanted to add?
No, thank you.
Okay. All right. This will close the hearing then on variance 21-0902.
Next case is item H2, variance 21-1256. The applicants Jerry and Patrick Police. The request is a variance to lot development standards and accessory structure requirements. Staff findings will be presented by Isis Brown.
Good morning, Isis Brown, Development Services, reporting on variance 21-1256. The applicant is requesting multiple variances to accommodate an existing single-family dwelling, a proposed garage, and, I'll start over. Per the applicant's rep, one of the variances have been removed. The shed on the property has been removed, and so we will not be addressing the existing detached shed on there on the northwesterly corner of the parcel. So I'll start over. The applicant is requesting multiple variances to accommodate an existing single-family dwelling and a proposed attached garage on a legally non-conforming lot that is zoned ASC1 and subject to the required building setbacks of the RSC2 zoning district. The subject parcel is a corner lot and therefore has a required front yard setback along the road frontages and required 2 side setbacks along the interior lot lines. The first variance for the existing single-family dwelling, per LDC section 6.0101, a minimum front yard setback of 25 feet is required in the RSC2 zoning district. The applicant requests a 16.1 foot reduction to the required front yard to allow an 8.9 foot front setback for the northerly lot line along Floresta View Drive. The second variance is for the proposed attached garage. Per LDC section 6.0101, a minimum side yard setback of 10 feet is required in the RSC2 zoning district. The applicant is requesting a 5-foot reduction to the required side yard to allow a 5-foot setback for the southerly lot line. Our findings. The minimum lot for is 1 acre with 150 feet required frontage in the ASC zoning district. The subject parcel is approximately 0.41 acre in size and has a 119.36 feet width and therefore is non-conforming. However, it has been certified a legal non-conforming lot per NCL 22-0118 in the record. Accordingly, it has been determined that pursuant to LDC section 11.03.03D, required building setbacks for this subject parcel are those of the RSC2 zoning district. This ends my report and I'm available for any questions.
Thank you. All right, applicant.
Good morning.
Good morning.
Hearing Officer Todd Pressman, 202nd Avenue South, number 451 in St. Petersburg. I'm here with Mr. Halezi, who is the property owner. If we could go to the PowerPoint, please. This is VAR 21-1256. Next slide, please.
Mr. Pressman, excuse me. So do you have a paper copy or a thumb drive you can leave? Great, thank you.
Right here. Would you like me to submit that now?
No.
Okay. Thank you, sir. Thank you, Mr. Isney. We're located in the north part of Tampa, Hillsborough County. Next slide, please. Located on Lake Magdalene Boulevard East. This is a quick picture just to orient you to the home. Next slide, please. And this is the survey of the existing conditions. The home is existing per under older zoning categories. As you've learned and as part of the record, there was a non-conforming use recently approved.
I'm sorry, Mr. Pressman, the non-conforming determined the size of the lot. Is that correct? It's a lot, non-conforming lot?
Yes, correct.
Okay.
Yes.
But not a use?
That's correct.
Okay, thank you.
Well, yeah, that's correct. So we're located on the corner of Floresta and Lake Magdalene Boulevard. Next slide, please. This is just a partial copy of the letter, which again is in the record of the non-conforming use lot determination. Next slide, please. This is just a quick look at 1973 zoning map, which was originally under AR. Next slide, please. Variances requested. Next slide, please. Again, as indicated in the record, all the sheds either are removed or will be removed, so there's no variances required or necessary for these sheds that are on the property. Next slide, please.
Both of the sheds?
Yes, correct, both sheds.
So I see 2 on this survey.
Correct.
Okay.
No, both will be removed. One is removed already, the other will be removed.
Okay.
So we're withdrawing any variances for the sheds.
Okay, thank you.
Thank you. The first variance is for the existing home, which was built to lot standards at the time. It just simply requests a setback recognizing the existing front setback. 25 feet is required. 8.9 is actually existing. It's a variance of 16.1. Again, that's in regard to the non-conforming lot issue that's been approved. The second variance is on the south side. I'm waiting for my dutiful assistant. Thank you, sir. Is on the south side for a proposed attached garage. Next slide, please. The proposed attached garage, again, is a side setback. 10 feet is required, 5 feet is proposed for the garage, and that would leave a variance of 5 feet. Next slide, please. We do want to make you well aware that Mr. Pleasy has spoken with the abutting neighbor to the proposed garage, and they are fine with it. They accept that we've had no opposition, and we have not heard or seen from anyone else from the public notice. Next slide, please. So this is just to orient you to the site. That's one existing shed to be removed. This is the existing driveway and just some of the vehicles of the Pleasy family. Next slide, please. The question is really, where can this attached garage be located on the existing site to meet the parameters or restrictions? Next slide, please. We do know that there's a lot of drainage issues here. This is a contour, but basically it shows that drainage, next slide, please, runs from the one contour line to the lake, which, as Mr. Police has indicated to me, does carry quite a bit of water drainage during storm events. Next slide, please. And there is a drainage system in place, which is a drain piping out to culvert, out to the lake system that runs specifically on this property. Next slide, please. And these are just some of the drainage elements, just to show you there's some drainage. That's one of the main drainage elements in the rear that picks it up, that runs through the site to the front. That's one of the drainage elements to the right. And then you can see a culvert as well and ditching that eventually is out to the lake. Next slide, please.
Mr. Preston,
Yes.
do you know whether those drainage improvements are original or were they added by a property owner?
Mr. Leeson. Answer for Mr. Polizzi purchased property a year and a half ago, and they were there when he purchased the home.
Okay, thank you.
The critical factor is we're trying to stay on top of existing impervious surface as much as possible to reduce any drainage impacts, inadvertently moving drainage one way or the other way. So that is partly why we're looking at moving into this area. Again, it's also the open area, but looking to be as much on the existing paths as possible. Along with the shape of the property, the existing conditions of the property, the existing home, which is on a non-conforming lot, was obviously built to code standards when it went in. Next slide, please. We know it's not overbuilt, or we pretend it's not overbuilt. The home and garage as a total would be 4,114 square feet. The lot is 1.02 acres. That would bring it into about a 10.8 FAR, which is very low. Res 4 is the future land use category, which is 0.25 or 4 units per acre for a residential site. ASC 1 really has no direct maximum build out standard. As you're well aware, that would just be parameters of setbacks and other things on the lot. So as far as we could look for a directional element, we see that the lot is not overbuilt. Next slide, please. And this is the Polizzi family. We want to make a note that there are 4 children. There's drivers and a lot of drivers in the home. And with your allowance, if I may ask Mr. Polizzi to come up and just speak to that for a moment, if I may, hearing officer. With your allowance, may I have Mr. Polizzi come up for a minute to make a couple comments?
Certainly, he's the.
Thank you.
Yes. Mr. Polizzi, please state your name and address for the record. Thank you.
My name is Patrick Polizzi. The address is 15102 Lake Magdalene Boulevard, Tampa, Florida, 33618. And I'm here to talk about why we need to have this garage. And we did just recently move to the house. We were currently in Tampa as well, in central Tampa, and we had a smaller house, but it did have a 2-car garage. And we decided to get a larger house for our family. And when we first moved into our original house, we actually got burglarized right when we moved in. And my wife had a big problem with panic attacks and everything after that happened. So that particular house, we had to put burglar bars on the house, and she's been very afraid ever since. Well, it's been years ago. That was like 15 years ago, and she's been doing much better, and we haven't had any problems. Well, once we moved into this new house, it was a nicer house, but it did have the flaw of not having a garage. Well, I didn't think about it being a big deal, but now the reason why we need the garage is because basically whenever she comes home at dark time, she has to call one of us or get one of us to come out and walk her in because she's afraid. So that's the main concern for the garage. And I also have two younger girls as well that are 19 and 17. But the main thing is my wife.
Thank you. And Mr. Polisi, please sign in with the clerk. Thank you.
And I would add, hearing officer, that as per the pictures, it's very dark at night. The trees are very overgrown to the road, so it's a very dark. And for someone who is concerned, and for younger girls, it is somewhat foreboding in that respect. And of course, the attached garage would be accessed through the home. They would not have to access the home by going outside. That would conclude our presentation.
All right, thank you.
Thank you.
Is there anyone here or online who wishes to speak in support of this application? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, don't hear anyone. Development services, anything further?
No. No, ma'am.
Thank you. All right, applicant, did you have anything further you want to put on the record? And you're going to submit your presentation. Thank you. All right, this closes the hearing then on application 21-1256.
Our next case is item H3, variance application 22-0016. However, at the start of the hearing, this application was withdrawn, which then takes us to item H4, variance 22-0066. The applicant is Adrian Mushasenig. The request is a variance to lot development standards. Staff findings will be presented by Isis Brown.
Good morning. Again, Isis Brown, Development Services, presenting variance 22-006. The applicant is requesting a variance to the required rear yard setback to accommodate a proposed addition to an existing single-family dwelling on a lot zoned PD 74-0004. The variance, the conditions of approval for PD 74-004 as last modified by PRS 21-0357, which does not address the setback requirements for the subject property. However, staff has determined that a minimum rear yard setback of 25 feet is required. The applicant requests a 10-foot reduction to the required rear setback to allow a rear setback of 15 feet. There were no additional findings. This ends my report, and I'm available for any questions.
Thank you. All right, applicant.
Hi, my name is Adrian Madison. I'm at 14003 Middle Park Drive, Tampa, Florida. Thank you very much for having me here today. This is just a homeowner at this address. I have a large family. We're just adding on to our residence to accommodate all our children. And this application also includes handicap accessible items to our family.
All right. Mr. Madhu Singh, is that correct?
Yes.
Madhu Singh. Could you talk about the property a little bit? Any variance has to be based on a hardship, and this is a hardship related to the property itself.
Yeah.
I understand the handicap accessibility. What are the hardships related to the size and shape of the property, or anything related to the property itself?
Right. We the hardship would be trying to find handicap accessible items In our area, I participate in our community, in our HOA, so it'd be very hard to relocate. And obviously our children's, friends and family and school districts. So it's not very easy for us to relocate and to accommodate space for four little children and with aging parents and so on and so forth. But the reason that we have to go back for the space is to keep the lines of the house. If we try to expand out, it wouldn't fit the lines of the house.
Okay.
We also reached out to proactively to the rear owner, who actually is the HOA, and they approved a variance. And I spoke to my two neighbors on my side, and also there's an apartment complex behind. I spoke to them, and there was no opposition.
Okay. So then just to clarify, you were just requesting a 10-foot reduction to the required rear yard setback to allow a setback of 15 feet. And the purpose of this is for a home addition.
Yes,
Okay.
please.
All right. Anything else you want to add?
No, thank you. Thank you for your time.
All right. I need you to sign in with the clerk here, please. All right. Is there anyone here or online who wishes to speak in support of this application? Do not see anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right. Don't hear anyone. Anything further from the Development Services?
No, ma'am.
Okay. An applicant, you have 5 minutes for summation if you wish. No? Nothing further. All right. Thank you. So this closes the hearing then on variance 22-0066.
Our last variance on the agenda today was item H5, 22-0068. However, that was moved upwards in the agenda and has already been heard. So that concludes our variances and then moves us into our special uses.
All right. Thank you. Call the first special use case.
First case is item J1, special use application 21-0915. The applicant is Regional Properties Incorporated. The request is for a special use permit for a community residential home type B with a maximum of 12 placed residents. Staff report and recommendation will be presented by Steve Beachy following applicant's presentation. Additionally, Planning Commission staff will provide comment.
Thank you, Mr. Hisney. All right, applicant, please.
Good morning, Russell Ottenberg, Planning Incorporated, 3737 Lake Joyce Drive, Land O'Lakes 34639. I do have some materials to be entered into the record.
All right, thank you. Please place those with the clerks. Clerk.
With me today is the applicant and a representative of the applicant, as well as Mark Bentley, local land use attorney, and Swapnali Salunki, the architect for the proposed facility. This is a special use request for a 12-bed type B community residential home at 3410 Pearson Road in Valrico. The proposed special use will consist of a single one-story building of 10,760 square feet. The building will house the 12 residents and also provide for caregiver staff space. The CRH will have normal and customary parking, stormwater, and other infrastructure necessary and required to facilitate its operations. The project will be serviced by public water and sanitary sewer. It is located on 4.28 acres of vacant land, the majority of which will remain undisturbed and or remain passive. Enhanced buffering and screening will be provided along all property lines, and the western 275 feet of the property, that portion that is most heavily treed and vegetated, will remain undisturbed. A little background on Sunrise Communities. They're a not-for-profit agency operating in 7 states, has provided services for people with intellectual and developmental disabilities for over 50 years in the state of Florida. And they support and have always supported people who have the most complex medical needs. This 12-person CRH would provide 24-hour care. Majority of the residents use wheelchairs and some may require feeding tubes. These residents typically do not have family to care for them, or their family members are unequipped to provide care for their complex medical needs. Sunrise provides the care that these residents otherwise would not receive. The purpose for this particular resident is to provide an opportunity for those persons supported to live in a community residence instead of an institution. This move to community settings has been mandated by the state and federal regulatory agencies. And the backup for all this material is in what I have submitted. In this home, each person will have an individualized plan to maintain good health and become as independent as possible in self-care, such as brushing teeth and other daily living tasks, such as cleaning their rooms. The home will include 24-hour awake staff, including licensed and registered nurses to assist each person to meet the goals of their plan. The state of Florida mandates each staff pass a background and screening and attend orientation before working. The Type B community residential home has a special use, has several criteria under Section 61128 of the Hillsborough County Land Development Code. And I'll list and then discuss how we've met these criteria. The first is that the CRH and Type B or C, because the Type C is also available as a special use in the ASC1 district, shall not be located as to result in the concentration of such community residential homes in an area. No community residential home Type B or C shall be located within a radius of 1,200 feet of another existing Type B or C CRH in a multifamily zone, nor within a radius of 500 feet of an area zoned non-agricultural RSC single-family zoning. We have reviewed and submitted to the county whether or not there are any other Type Bs or Cs within 1,200 feet, and there are not. The county staff has opined, and we concur, that the lack of the other CRHs in the area, coupled with the nature of the proposed CRH, makes the 500-foot separation from the non-ag RSC zoning waivable. Second criterion is the requirements and standards of the Florida Department of Health and Rehabilitation Services shall be met, and the applicant commits to meeting those standards. Third criterion states in all other CRHs, it's really just the density calculation for the CRH. Again, this is a 12-unit or 12 resident rather CRH. Type B can go up to 14, so it's not even going up to the full density. The required acreage calculation for the CRH requires 2.4 acres. We have 4.28 acres. And in fact, given the acreage, if the applicant has so desired, they could have requested a Type C CRH with up to 21 residents. So this is about a 50%, a little more than 50% of what is available as a special use. Lastly, it says each facility shall, I'm sorry, there's 5. The fourth is each facility shall provide adequate parking spaces as required in 60500 of the LDC. The special use site plan and the staff report both show that the minimum parking requirements of Hillsborough County are met. The last requirement is each facility shall be designed and built to appear as similar to a residential structure as possible. I do have a rendering I'd like to put on the Elmo. This specific LDC criterion is derived, at least in part, from the Hillsborough County Future Land Use Element, Policy 1.4. The FLU policies provide, and I know you're aware of this, provide the basis from which specific LDC regulations and criteria are promulgated. Hillsborough County, in assessing how Flu Policy 1.4 for development of criteria specific to Type B residential community homes, has determined the above criterion is what should govern for this specific use. That is, it should be designed to appear as similar to a residential structure as possible. Furthermore, this criterion does not require the structure to be as similar as possible to the surrounding homes, merely to be as similar as possible as a residential structure. In fact, I would say the criterion specifically excludes building scale as a criterion, given that the scale of a Type B community residential home or a Type C, which is available again as a special use in this zoning district, the Type B can hold up to 14 residents, a Type C can go up to 21 residents. And so by necessity, a Type B or a Type C may be larger or would be larger than the surrounding residential homes. And so scale is not a criterion. It is simply that it needs to be as similar to a residential structure as possible. The architecture for this has been designed to take into account a lot of the elements in the architecture in the residential structures in the area. It includes front porches, dormers, shutters, porticos, those types of things that are found in the area. It is one story, it is low, and so it is a very residential looking structure, as you can see in the rendering, the elevations, and staff has also opined that it meets this criteria. Consequently, this criterion refers only to the architectural design elements, not scale of the building, such that the architectural design elements incorporated into the building, again, appear as similar to a residential structure as possible. It's also important to note, I believe that there is no HOA, nor is there an architectural control committee that governs this property or the properties therein. So there are no other architectural standards that pertain to this structure. The staff report concludes that the proposed CRH is compatible and consistent with existing residential uses and density. Further, it does not object to the distance waiver request, as there are no other Type B CRHs within 1,200 feet of the subject home or Type Cs. The staff report also includes a number of recommended conditions of approval. The applicant agrees with those conditions. A copy of those are also included in this report. I'd like to talk for a minute about community outreach. After we had sent out the required letters by the county, we sent out another set of letters to everyone on that list saying we wanted to have a virtual community meeting. It listed the time, the date, the call-in number. We sent it to everyone on the list. Copy of that is also in the package. We got no response. There were no emails, no calls. We started the conference call, waited for 15 minutes, no one attended. We also were forwarded some letters of objection from Steve Beachy, and I personally reached out to those folks and said, hey, talk to you about anything you want to discuss. I got no response. Subsequently, and prior to the last meeting where we were scheduled to be on, just a couple days prior to that, I did get notice that some of the community members wanted to talk. So we continued the hearing to do so. Met with them and discussed their concerns and what we were doing to address those concerns. I'd like to talk about a few of those right now. Traffic was a concern. There was the idea that this was going to generate a tremendous amount of traffic, when in fact it will generate less traffic or fewer trips than what could otherwise be developed on the property. Seeing as this is a 4.2 acre parcel and it's ASC1, you could have up to 4 individual homes, each of an acre, with an aggregate aggregate traffic much greater than what we would otherwise have. Wetlands, flooding, and stormwater, we're concerned. We are there are no wetlands. It's not in a flood zone. As far as stormwater is concerned, we're going to capture the 100-year storm and retain it on site. So we're actually going to lessen the impact of larger storms by retaining all the water on site. So that is not an issue. Crime was a concern. There was the thought that some of these folks were perhaps criminals or would be wandering the neighborhood committing criminal acts, when in fact they're wheelchair bound under 24-hour supervision. No one's going to be walking around the neighborhood. The main issue is the intensity of development, as I understand it, and concern over the size of the building. As I've already said, the 10,760 square feet and 12 residents is much less than what could otherwise be done under a type C, which is also a permitted special use in this zoning district. And in fact, it's an R4, Res 4 land use category. And where it rezoned, I believe the county requires a minimum of 75% of that. So 4.28 acres, we're looking at 17 units gross, maximum 12 units minimum. So this could be a much more intense develop if it was developed otherwise as a residential subdivision. Although there are no FAR limitations in this zoning district, the future land use element does have a 0.25 FAR limitation, just generally speaking. And I know it's not calculated this way, but for the purpose of discussing scale, that would allow up to 46,000 square feet approximately on the property. We're at 10,760. We're at a quarter of that. I know the staff report also did an analysis of FAR basically for us versus what is all the surrounding properties, and found that we were consistent with what is going on there. We also have letters of support in the package that I submitted. So in summary, the proposed CRH is consistent with the requirements of the Hillsborough County Land Development Code. It's compatible with the surrounding residential units or residential uses, will generate less traffic than the 4 single-family residences that could be developed on the property by right, no non-administrative hearings. Will not adversely affect wetlands, will not increase, but will likely decrease flooding due to stormwater management undertaken as part of the project. Will not impact wells or groundwater, will retain significant portions of the property in their natural state and passively as well. Proposes substantially more buffering and screening than required by the LDC. Commits to building setbacks far exceeding those required under the AS1 zoning regulations. Commits to no identifying signage. Commits to maintaining the western 275 feet of the property as a buffer, and is supported by Hillsborough County staff with a finding that the development is consistent and compatible, and staff recommends approval subject to certain conditions. Given all of the above, the applicant respectfully requests approval, and I'm happy to answer any questions.
Thank you, Mr. Rott. I don't have any questions for you.
Great, thank you.
Thank you. Mr. Ott, please sign in with the clerk's office. All right, development services.
Hello. Wait. Hello. You all moved really fast. Sorry about that.
Tim.
Yeah, actually, yes.
We're on the case before yours.
Oh, okay. Sorry.
Yeah,
My
thank you.
apologies.
Hey, Steve, you seem to be muted.
Yes, can you hear me now? I
Yes.
apologize. That's probably why Tim jumped in, because there was a vacuum of sound there.
Yeah.
Okay. Pursuant to Land Development Code Section 61128, the applicant requests special use approval for a proposed community residential home Type B with a maximum of 12 place residents. The request includes a distance separation waiver to allow the proposed home to be located within a radius of 500 feet from the property that is zoned RSC2. The site is comprised of 2 parcels with a total of 4.28 acres zoned AS1 and located in the urban service area and designated Res 4 in the comprehensive plan. The proposed community residential home will have a maximum of 10,000 square feet of floor area and conforms to permitted density as required by the Land Development Code, Section 61128. The surrounding area is primarily zoned AS1 with the exception of the parcel zoned RSC2 along Pearson Road, totaling approximately 2.5 acres. Per the Land Development Code 61128A, the proposed community residential home type B shall be located at least 1,200 feet from existing type B or type C community. The applicant has submitted licensing data from the state indicating that it conforms to this requirement. The proposed community residential home will be located approximately 172 feet from the RSC portion of the 1.8 acre parcel to the east across Pearson Road that is therefore requesting a 328-foot waiver to the required 500-foot separation from the parcel zoned RSC2. Per Land Development Code Section 61128E, a community residential home type B shall be designed to appear similar to a residential structure as possible. The site plan submitted by the applicant includes design elevations for the proposed community residential home, which include pitched roof, dormers, covered entrances, and window shutters. Staff finds these design elements are characteristic of the residential design and reflect design elements found in some single-family homes in the area. Regarding setbacks and buffering, the applicant has indicated they will exceed the required setbacks and buffering on the site as detailed in the staff report. Transportation staff indicates the proposed community residential home is expected to generate 31 vehicle trips per day as opposed to 38 vehicle trips per day that could be generated if the property were developed with single-family homes. Planning Commission staff has found that the community residential home is consistent with the comprehensive plan. The staff findings for the proposed community residential home with existing uses in the surrounding area find it compatible for the following reasons. A community residential home is a residential use as defined by the Land Development Code of generally benign nature and limited nuisance potential. The design of the community residential home will incorporate multiple design elements that are characteristics of residential design and reflect design elements found on some single-family homes in the area. The relative large size of the host parcel resulting building coverage is approximately 6%, which is congruous with the range of building coverages on the single-family lots, which vary from less than 1% to more than 12%. I have a graphic that I would like to share with you. Can you see that?
Yes.
Okay. This shows the subject site, which is at 6% lot coverage, which is in the middle of what the lot coverage is for the lots in the surrounding area. The larger, there's some lots that have 8.3, 11.9, 8.6, and 12.3% lot coverage. And then some are in the mid-range, 5%, 6.3, and this parcel would fall in that mid-range. And obviously there are some parcels that are much lower lot coverage than what this parcel will have ultimately. Let's see. Well, I'm trying to share my screen again, but I'll just go on with the remainder of the staff findings. The proposed setbacks for the subject community residential home substantially exceed those required by the property's AS1 zoning, as well as the existing setbacks found in the neighboring properties. Additionally, the proposed buffering and screening will exceed that required by the Land Development Code for the proposed use. Finally, the proposed community residential home will be substantially screened from the neighboring parcels and Pearson Road by perimeter buffering screening, which will include a row of 6-foot-high hedges along road frontage. For these reasons, staff finds the proposed community residential home approvable, subject to the recommended conditions in the staff report. I'm available for any questions.
Thank you, Mr. Beachy. All right, we'll hear from Planning Commission.
Hi, good morning, Madam Hearing Officer. This is Jillian Massey with Planning Commission staff. Before I begin my testimony, I just wanted to note that last Thursday, December 9th, we made a minor revision and correction to our report. We did provide a copy with Mr. Hisney, so my testimony is going to be based off of that report.
Okay, we don't see Ms. Massey on the screen.
Mr. Steve, we need to have you to unshare your screen.
I am trying to do that right now. I'm not finding a button.
Okay, if you look at the top center of your screen, there should be like a little orange.
Oh, yes.
There you go.
Stop there. There we go.
Thank you.
Can you see me now?
Yes, we can.
Okay, great. Okay, again, this is Jillian Massey with Planning Commission staff. The subject property is in the residential 4 future land use category. It's in the urban service area and not located within the limits of a community plan. The proposal meets the intent of Objective 1 and Policy 1.4 of the future land use element of the comprehensive plan by providing a residential support use within the urban service area. The proposal meets the compatibility requirements of Policy 1.4 as the predominant character of the area is single-family residential dwellings at comparable densities. The proposal is also an acceptable transition between the existing parcel owned by the nonprofit organization Florida Audubon Society and operating as a bird sanctuary. The existing residential support uses, which is a church and cemetery to the west, and the single-family residential that surrounds the site. The staff report filed initially for this application previously identified the parcel owned by Florida Audubon Society as a multifamily development, as shown by the parcel data provided by Hillsborough County property appraiser. This revised report has rectified this issue. The subject site, again, is located in the residential 4 future land use category. A community residential home type B is a residential support use that can be considered in the Res 4. According to Objective 9, Policy 9.1 and 9.2, the proposed use must comply with all local, state, and federal land development regulations and comply with all requirements for the operation of a community residential home type B and demonstrate that there are no similar facilities within 1,200 feet. The applicant has submitted verification that there are no such facilities within 1,200 feet and thus meets the intent of FLU Objective 9. The applicant has asked for a distance separation waiver to allow the proposed use to be located within a 500 feet radius from an RSC2 zoning district that is also supported by Development Services. The proposal also meets the intent of FLU Objective 16 and its accompanying policies that require new development, infill, and redevelopment to be compatible to the surrounding area in character, lot size, and density. The applicant is proposing 12 beds, which will complement the existing residential density per household of the surrounding area. As the subject parcels are currently vacant, the proposed special use provides a compatible transition of uses from the development to the west and single-family residential on the east, north, and south sides. Access will be provided via Pearson Road, and the applicant has submitted several elevations that demonstrate compatibility with the surrounding area. Objective 17 and Policy 17.1 permit the development of residential support uses in all residential future land use categories. And since this is located in the residential 4, it is therefore permitted. Objective 20 and policies 20.5 and 20.6 support the development of congregate living facilities within unincorporated county, subject to limitations. The applicant has demonstrated that no existing facilities are within a reasonable distance to prevent excessive concentration. And therefore, the proposed special use meets the intent of Objective 20 by providing innovative housing for all residents of Hillsborough County. Finally, Goal 12 and Objective 12-1 of the community design component in the future land use element requires new developments to recognize the existing community and to be designed to relate to and be compatible with the predominant character of the surrounding area. In this case, the surrounding land use pattern is low density, single family residential. Other uses in the area include a bird sanctuary, a church, and a cemetery. The proposal would be compatible with the existing development pattern. And based upon these considerations that I've outlined, Planning Commission staff finds that the proposed special use is consistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County, subject to the conditions proposed by the Development Services Department. And that concludes my report. If you have any questions, I'd be happy to answer.
Thank you, Ms. Massey. All right, at this time, I would like to ask, is there anyone here or online who would like to speak in support of this application? Any proponents? All right, I don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? Any opponents? All right, need you to state your name and address for the record, please, and speak into the microphone.
Yep. Excuse me. Yes, ma'am. Excuse me. Howard Bryant, 3618 De La Rua Place in Valrico. There's also two other folks that will be speaking after I do.
All right. Altogether, you have 15 minutes.
All righty. Thank you so much. I have provided a thumb drive with a slide presentation, and the gentleman will have it up, but also if I could put into the record. Put into the record those particular documents.
All right. Is that a copy of your slide presentation?
Yes, ma'am, it is.
Okay, thank you.
On the, obviously, I'm speaking in opposition to what we have heard thus far for the special use. But if you'll go to the next slide, we know these words and we've heard them. We know that land development code is very specific to what's occurring here. And in the particular one identified on the left, it does say that the facility shall be designed and built to appear as similar to a residential structure as possible. If we go to the right side where we have the future land use element articulated in terms of policy 1.4, it speaks to compatibility. And as you go down through some of the items that I have underlined, you'll notice that I have keyed in on some aspects or elements that affect compatibility, specifically scale, even though the applicant has suggested scale should not be considered here as strongly as perhaps we believe it should. I'm going to demonstrate in a few minutes that it is very much applicable to this particular case. And then if you move along, you'll see mass and bulk of structures, you'll see parking impacts, and then finally the architecture. And at the tail end there, it does say that compatibility doesn't mean the same, but it does refer to the fact that it needs to be sensitive in maintaining the character of existing development. Next slide, please. Similar to what Mr. Beachy had on the screen earlier, this is the area of concern. The red star is the proposal. And those are simply, those other lots there are simply 23 other homes that are either adjacent to or they are incredibly close to them. And in most cases are visually within sight of that particular facility. Next slide, please. I've taken one element that is glaring and I've put it on a bar graph. This data is coming out of the 23 homes, those lots that are demonstrated on the previous slide. And then the tall one in the middle, item number 6. That is the proposal. And so what I'm attempting to do is pictorially or graphically represent by scale the enormous size on a square footage basis of this proposed development relative to the other 23 homes.
Mr. Bryant?
Yes, ma'am.
Could I ask, please, are you speaking on behalf of yourself as a surrounding property owner?
Great question.
Or are you representing other property owners and your credentials?
I am absolutely speaking on behalf of myself.
Okay.
But in terms of the community, the neighborhood,
Okay.
as we began to meet and have discerning thoughts on what to supply here, somehow they asked for a volunteer to step forward. I didn't move, and so I got elected.
Where is your property in relation to the subject property?
If you'll go back to the previous slide, it is number 24 on the lower right-hand side.
Okay, thank you.
I'm approximately 1,200 feet from the star.
Okay.
Okay. Next slide. One more. A busy table, but here's what I'm trying to demonstrate here. I'm taking the 23 properties and I am identifying what I believe to be 4 key elements that need to be considered if we're going to make a fair determination of compatibility. And so along the bottom in the yellow, I'm going to highlight 4 particular rows of data. First, the range of the 23 homes on the table above. The square footage goes from 1056, as you can see, to roughly 4,000. The bedrooms, 2 to 5. The parking in those particular homes is 2 to 6 vehicles. The building length, the front elevation, as you look at it, the length is some 38 up to 94 feet. If you go to the average now of those 23 homes, you'll come up with the numbers that I have on line 2, which happens to be 2123 for square feet, 3.1 bedrooms, 2.3 parking, and 65 linear feet in front elevation. Now, the third line is the proposed development. As previously stated, it is 10,760 square feet. There are going to be accommodations for 12 residents. I'm calling them bedrooms, but there are 12. Parking has been identified to be for 20 vehicles. The building length, which is determined by scale, comes off the architectural rendering that has been supplied in previous filings into this record, and it's 245 feet. If you go to the bottom line, and I'm going to address scale at this particular point in time because I think it has impact in this decision. If you look at what the proposed home has relative to the average of the 23, you'll notice the square footage is 5.1 times greater than the average. The bedrooms, 3.9, the parking, 8.7, and then the building length is 3.8. We suggest, as the 20 homeowners behind me would suggest, there is an issue of scale here. There is an issue of scale. A couple of us met with the county staff trying to make a determination earlier as to how do you manage or how do you determine, how do you take scale, which is coming out of the policy 1.4, how do you make application of it to a home like this? The answer we received was judgment. And I got to thinking about the word scale. Scale means measurable. Scale does not mean strictly judgment, but it can be judgment applied to measurements. I am providing measurements along the bottom in terms of the scale. And so I would suggest that this facility is out of scale. Now, those are numbers. That's data, which again needs to be used to determine scale. But if I could have the gentleman go to the next slide. I'm going to quickly run through some pictorial demonstrations of existing homes that are part of the data and the architectural rendering that was provided to us. And let me touch for just a minute on that architectural rendering. That's the revised copy, if you will, that's been filed. The first one had 3 porticos. This one has 1. The first one had no dormers. This one has 2. And the interesting part is this slide became available as a revision after we met with the applicant's representative and began to discuss the non-compatibility, the lack of harmony with the surrounding community. This was what was developed. The drawing that you saw earlier that was laid here by Mr. Ottenberg, we have never seen that, nor does it come anywhere close to what that building looks like there, which is on record right now as being the architectural rendering of the front elevation. And so I would submit this is perhaps a little bit more accurate. Now you think in terms of that building there, what you'll notice is it's the front and there are 5 doorways into that facility. We are not aware, in fact, it doesn't exist. There's no home within our community in any direction that has 5, what I would call front doors. There's no, that is multifamily looking. That was originally described by the applicant as being a quadruplex. And now it has changed to being described as a single family type living unit. I'm struggling with seeing what was originally called a quadruplex with 3 porticos and now 1 portico, and yet still having the 5 doors that enter in some form or fashion into that facility. Typical home on the left. If you go to the next slide, and I'll spin through these quickly as our time continues to erode on us. Again, making the comparison, 25 to 10.7, 73 feet in length versus 245. Next slide. Another home, 3666, 81 feet across the front, compared again to the architectural rendering that was revised. Next slide. This is the largest home out of the packet of information that I've provided. It's roughly 4,000 square feet, 80 feet in length, still a porch, a single family home, 1 entrance, but again, compared to the architectural rendering, 10,760 feet. Next slide. This home is 2369, 73 feet in length, compared again to the 10,760. I could supply more pictures. I have them. I've provided them in various times with meetings, specifically with the staff. It demonstrates the same thing, the lack of compatibility. I guess I would, I don't guess, I know. I'm going to share with you an incredibly quick story, and that is this. All of us have from time to time driven down roads where there's residential development occurring. And as we drive down and we see that development occurring, not unusual to have a sign out front or in front of that that says future home site, developer name, builder name, and you'll see some key pieces of information. You're going to see the minimum price typically. The second thing you're going to see is a stated range of square footage. It could be 2,000 to 25 to 3,500. You continue on and you're going to see oftentimes bedrooms, 3 or 4. And finally, you're going to see oftentimes the garage accommodation, 2 or 3. If I was to drive, or if any of us were to drive into that kind of a potential development and we saw that building, we would suggest that is not compatible with what that sign says. It's just not. If a sign was situated on the streets that enter in to our particular neighborhood, it would have similar data. But the minute that is seen, it's as if what happened? We are missing compatibility here. And so our request is that proper judgment be applied, number one, and number two, it would lead to a denial. Thank you.
I have one question for you, please.
Yes, ma'am.
So your objection focuses in on the scale, the size of the building. So do you not have any objections then to the use? As a community residential home type B, you don't object. It's just to the size and scale of the building. Is that correct?
That is an incredibly worthy cause that they have. And we would not object to that. We simply would suggest exactly 2 miles up the road is a piece of property that takes less development, and it is sitting there ready to go, already zoned for this kind of activity to occur. Thank you.
Thank you. Be sure and sign in with the clerk.
I will do that.
Yes. Other opponents, please come forward. State your name and address for the record.
Good morning. My name is Don Hemke, Hemke. I'm an attorney with Carlton Fields, Tampa, for the past 42 years. I do land use litigation, land use advice, represent governments and sue governments. Address, West Boy Scout Boulevard, Tampa's office address. Home address is 12837 Darby Ridge Drive, Tampa 33624. The issue here is whether this is it may be a worthwhile project, but it is not a community. It's not a within this particular classification in the AS1 zoning category, because basically what they will be providing will be nursing services. I have some materials here which I will leave. Rather than go through everything, it could take a lot of time. But basically, it shows how things have happened here on this particular project. Because it's in an AS1 zone, it basically says that community residential homes shall not be deemed to include nursing, convalescent, and extended care facilities. This is probably a convalescent adolescent, certainly a nursing facility. That is precisely what is said in the early letters here. Basically, on August 23, applicant wrote a letter to the here, which basically said the home will include 24-hour awake staff, including licensed and registered nurses, to assist each person in meeting their goals of their medical and programmatic plan. Many of the persons will use wheelchairs and they may require tubes, feeding tubes. The people living in the home are completely dependent upon others for their care. They have medically complex needs. Staff will be, and then there was a meeting with Mr. Rottenberg on November the 8th, 90-minute meeting, which our people attended, have copious notes. Again, he repeated, residents have medically complex needs. There's going to be staff there, nursing staff 24/7, will be a nurse and staff. When asked why the facility could not be built so as not to resemble a commercial building or an apartment. Basically, apartments, by the way, as are duplexes, as are any multifamily, are prohibited uses in the AS1 zone, and which goes to the compatibility issue. Basically, the applicant's representative indicated that the two-story homes would be too expensive and not economical to run. So, but on November 15th, there's another letter that comes from the applicant, which basically is part of the packet that I have gathered here and will provide, that Sunrise is expecting to build a quadruplex for residents that require total care for 24-hour nursing. We don't think it qualifies as what it is here, with the intention that the residents stay in their home for the end of till the end of the life. Because of the medically complex of the residents, the buildings must meet health code things. And most residents will have total assistance from staff and nursing, once again, for everything else.
Mr. Hemke, the time is up for the opposition. How many additional persons who wish to speak?
Well, there's one other one. We would ask, Madam Hearing Officer, if you would read this carefully, because after we write the oral letter of November 24th, basically, which points out that this is cannot be done as a special use in an AS1 district, they back away from it on nursing, but still there's going to be nursing which is required there.
I understand that. Thank you so much.
Can I leave these? And I will leave these, but we have one other person who basically will just tie the loose end together about nursing, please.
You may leave your documents with the clerk and I will review them. Ma'am, can you make your comments within 2 minutes? All right, come forward and Mr. Hemke, please be sure to sign in with the clerk's office and leave your materials there. And I'm going to extend the time by 2 minutes, and I'll do the same for the applicant. For your rebuttal, you can have an additional 2 minutes.
Okay, thank
Yes,
you.
ma'am.
My name is Debbie Burnett. I live at 3446 Parish Ridge Lane, Valrico, a couple streets down from the property. I am a licensed occupational therapist. I have been for 26 years with a specialty with geriatrics, cognitive, intellectual, and developmental disabilities. My proposal is this as well. This is not a group home. It's being labeled as a community residential home type B, but it is not, based on the findings that I found in the land development code. And I sent 2 letters, one with the first part, and the second time when Mr. Ottenberg denies that there will be nursing care. I will have to say that as a therapist and in the medical field for all those years, that isn't going to happen. They do need nursing care. Unlicensed nurse, unlicensed professional person can give medication. They can put it in their hand. They can say, take it. They just can't do this. But these folks have PEG tubes, which is a tube going into their stomach because for some reason they can't swallow, they'll choke, they'll get pneumonia. So you have to put medication in the tube by a specific procedure. And I've taught people to do this, those that were cognitively, intellectually aware to do this. So a nurse has to do this for these folks. So my contention is this is not a type B home.
All right, thank you.
And I don't like the scale. It is out of whack. So is that my 2 minutes? Now,
I think there's a timer there.
27. Okay, so do you read these letters that I sent?
I will read everything in the
Because it
filing.
shows you exactly, I went from land code development right to the Florida statutes, the nursing statutes. And if you follow it, which I believe you'll be able to make sense of it.
I will read them.
All right, thank you. What was your name again?
I'm Pamela Hatley. I'm the land use hearing officer. Please see the clerk. And Mr. Hemke, I have one question for you, just right quick. And I meant to ask you while you were speaking, were you representing yourself as a surrounding property owner, or are you representing property owners in the area?
I'm a property owner in Hillsborough County, but not in this area of Hillsborough County. I was representing my client and who is the spokesperson for a large group of people.
And they live within?
They live right next to it and then beyond. There's 149 letters which they have written.
I'll review them. Thank you, sir.
You're welcome. There is one other.
Well, the time's up for the opposition. I'm sorry. I need to move on.
Yeah, may I just leave it with the clerk then?
Certainly, absolutely. Leave all your materials with the clerk. I will see them.
Just so there, one sentence tells what it is. It is basically a list of group homes, which have basically was provided as part of the record in this case, and which shows that less than 1% of them are more than 6 or 7.
Okay, that's what you're submitting. Thank you, sir. Thank you. All right. Special uses. County Development Services. Do you have anything further?
No, ma'am.
Okay. All right, applicant, you have 5 minutes for rebuttal, but I'm giving you 2 more, so 7 minutes total.
Thank you.
And could you please speak to what kind of services there will be at this proposed use?
Sure, that was going to be part of my my response. First, wanted to address the size and scale issues again. Again, scale is not a criterion. It is, as I noted previously, the specific criterion in the Land Development Code are derived from the comprehensive plan. The Planning Commission has already opined in their expert opinion that this is consistent and compatible in terms of size. So has Development Services staff. The actual size of the building is not an issue. Again, it could be up to a type C CRH under a special use, which could have 21 people in it. And as a type C CRH, if you were to just roughly extrapolate from the size of this building to 21, you'd be at about 20,000 square feet, which is, again, still less than the 46,000 square foot FAR cap, if you're looking at it from that perspective, in the flu. I'd like to correct something Mr. Bryan said. He said it only had one portico. It has always had 3 porticos. Okay, the rendering that I showed and was submitted shows 3 porticos. Their elevations show 3 porticos. The only thing that was added were dormers. Otherwise, the building footprint and the elevations have remained unchanged. As to some of the things Mr. Hemke said, this is a CRH, it's a community residential home. We have had subsequent clarification with staff. Some of the confusion that has occurred has been entirely my poor semantics in trying to express what is going on here. But we've applied for a CR type B community residential home. We're going to be a community residential home. We have committed to staying within the parameters of what a community residential home provides in terms of services within the definition found in the LDC. That's it. We're not going beyond that. Nursing is a separate license through ACA. We will not be seeking a nursing license through ACA. This is going to be a type B community residential home licensed by ACA as a type B community residential home. That's that. It is not multifamily. It is a residential use in accordance with the code. And that's it as far as those things. I would like to give the rest of my time to Mark Bentley to respond to some other items.
Thank you.
Thank you.
Good afternoon, Ms. Hatley. How are you doing? Okay, just a couple of points. My name is Mark Bentley. Been a member of the American Institute of Certified Planners since 1989. I guess that's 32 years. I'm certified by the Florida Bar as an expert in city, county, and local government law.
Address.
401 East Jackson Street, Tampa 33602. I'm kind of testifying planning issues. That's why I'm giving you these credentials. I mean, a former planning director of City Oldsmar, Florida, former planner with the Planning Commission, former planner with Development Services in Hillsborough County. Just like to point out that, first of all, Mr. Hemke, he filed a letter indicating that he represented solely Mr. Howard Bryant. It seems like by extension, it was kind of hazy. He didn't identify any other specific clients, but by extension, he represented some other unknown people. But I'm just bringing your attention. In the record, he represents Mr. Hemke, Mr. Bryant. Secondarily, Mr. Hemke is testifying, didn't give any credentials solely as an advocate. And under Florida law, that's not considered substantial competent evidence. Next, there are 3 agencies that recommended approval, finding consistency, compatibility, and that is Development Services, Planning Commission, Russell Ottenberg, who's also been a professional planner for about 30 years, and that's not an agency. Next, concerning Mr. Bryant, Mr. Bryant didn't give any credentials. Also, he does not have legal standing if there were an appeal filed under the Renard case, which you're very familiar with. Under Renard, you must have a definite interest exceeding the general interest of the community shared with all citizens. In doing that, you consider the proximity to the property, character of the neighborhood, and common characteristics such as restrictive covenants and setbacks. Mr. Bryant lives so far away, actually, he would not have a right to appeal this case. Obviously, local government can make up whatever standards they want, but I'm just talking about from a legal standpoint. You know that if this ultimately a petition for writ of cert were filed. So I'm going to give you the Renard case. And also I wanted to show you on GIS,
and that microphone isn't on. Thank you.
Here's the subject property, Ms. Hanley.
Mm-hmm.
And then here's Mr. Bryant's property here. Obviously you can't see it, and we measured that. It's over a quarter mile away. So clearly this CRH would not impact him. So I know we're pressed for time. As I mentioned, there's no testimony from Mr. Hemke. The case law that's applicable to this proceeding, which you're familiar with, is the Irvine v. Duval County case, where the Florida Supreme Court adopted the dissenting opinion of Judge Zimmer. And that states basically once the criteria is met, as determined by professional planning staff and substantial competent evidence, which we have here, then the burden shifts to the government to establish by substantial competent evidence in the record that they didn't meet the standards. So we don't have that in this particular situation. So here again, this is a quasi-judicial proceeding, and to the extent you've received any evidence, it appears with all due respect by a non-qualified person, Mr. Bryant, and then just some advocacy by Mr. Hemke. So the clients met all the criteria for a CRH, and they would respectfully request your positive recommendation or approval. Thank you very much. I appreciate it. And I'd like to give you Irvine, Renard, and I guess you have Mr. Hemke's letter. Then I'll give you this map too, the one I just showed you in the Elmo. Thanks a lot.
Thank you, Mr. Bentley. Mr. Ottenberg.
I believe that concludes our rebuttal. If you have any questions, be happy to answer.
Thank you. I don't have any questions for you. All right, that will conclude the hearing then on special use 21-0915. All right, we're going to take a break and come back in about 5 minutes. So just a quick 5-minute break, and we'll come back and hear the next two cases.
Attention, we are live in 3, 2, 1.
All right, welcome back. This is, we're going to continue the meeting. This is the December 13, 2021 Land Use Hearing Officer meeting. And when Mr. Hisney gets back to his seat, we're ready to introduce the next case.
As our next case on the agenda is item J2, special use application 21-1333. The applicant is Hindu Temple of Florida. The request is to allow a church with more than 300, a special use permit for a church with more than 300 members to be located on a local road. The request also includes some variances to lot development standards and fence requirements. Tim Lampkin will be presenting staff report and recommendation following the applicant's presentation. There will also be comment provided by Planning Commission staff.
Good morning, Ms. Hatley. For the record, my name is Patricia Ortiz. I'm with Ortiz Planning Solutions. My address is 2810 North Central Avenue, Tampa 33602. Today I'm representing Hindu Temple of Florida and a special use request. This property is located along Lynn Road between Nixon Road and Anderson at the intersection of Williams Road. It's a two-part development site with the existing Hindu temple located on the northern parcel and a more recently acquired parcel on the south. The intent is to construct a multi-purpose building on the southern parcel. More specifically, that would be a Vidyala Center, which is a multi-purpose building within which there will be a cantina, administrative offices, and classroom for religious study. There will be no banquet facility use, and this proposal does not request an increase in the area of worship. The surrounding area is comprised of a mix of residential and residential support uses and is influenced by the Hindu facilities, including 3 other Hindu churches, the Indian Cultural Center, and Hindu Village, which was approved as a planned development for housing and is intended to house visiting priests and elder devotees. Back in 2019, a special use was granted allowing for the expansion of Hindu Temple. This approval allowed the 2 parcels to be joined under one development order, and it allowed for the construction of the Vidyala Center on the southern parcel with waivers and variances. After zoning approval, but before construction, meetings were held between the newly elected board of directors, member donors, devotees, and the construction team, and it was determined that the special use as approved did not accommodate the site improvements as envisioned. And as you are well aware, the special use cannot be modified like a PD. Instead, a new special use must be asked for. So we're seeking to retain those waivers and variations granted through the 2019 approval, which I have listed here. Thank you. And I'll quickly read those. A church to be located on the north and south sides of Lynn Road near the intersection of Williams. Waivers to allow a church with more than 300 members to be located on a local roadway. Variations to reduce the northern and eastern front yard building setbacks of the southern parcel. Variations to parking requirement. A variation to increase the walking distance between the parking stalls and the principal use, and for shared parking between the multipurpose building and the existing temple. Today, we're here before you seeking to retain those previous approvals, to increase the height and building area of the Videalis Center to be constructed again on the southernmost parcel, to reduce the southern side yard setback of the Videalis Center, to increase the building height of two existing multipurpose buildings located on the northern parcel, and to increase front yard fence height from 4 feet to 6 feet. And I will show you here on this diagram more specifically what I'm speaking of. In blue, we have the Videalis Center building highlighted, and in green, I'm showing you the area of reduced setback. So we're proposing to increase the area of this building and decrease the setback. Also, we're proposing an increase of height from 30 feet to 35 feet. On the northern side of the parcel, highlighted in orange are two existing multi-purpose buildings. One is the southernmost is a multi-purpose building. The northernmost is a prayer room. What we want to do is increase the height of these buildings with no additional floor area, just to increase the height to give a more pleasing aesthetic, especially as you're traveling down from the east heading towards the temple. So again, no increase to area of worship. We are asking for an additional variation, and that is to increase front yard fence height. We want to increase the front yard fence height along both Lynn and Williams Road. The fence will be constructed of masonry columns and metal pickets, and it will not interfere with site visibility. It will be located as shown here in blue. Again, along the project frontage and on both Lynn and Williams Road. And now I'd like to show you a couple renderings of what the new building will look like. Here we have the building looking from the north to the south, and we see both Lynn and Williams Road. Here you'll see the temple as you're coming from the west heading east. You see the Hindu temple on the left and the new Videalis Center on the right. And just one more. I recognized rather late in the game that there were some conditions that needed to be amended. Condition number 3 has a scrivener's error. The minimum north front yard is listed at 50 feet, but the previous approval allowed 20 feet. And the minimum east front yard setback was listed at 50 feet, but it was approved previously at 10 feet. Our requested variance is correct, minimum southern side setback of the southernmost parcel, 20 feet.
Say that again, please.
Okay. The condition number 3. Okay. It states the multipurpose building located on the south side of Lynn Road shall comply with the following development standards. Maximum floor space, 21,531 square feet. We have no issue with that. Maximum building height, 35 feet. No issue there. Minimum north front yard setback is listed at 50 feet. We're proposing a change in this condition to reflect the 20-foot setback that was previously approved.
Okay.
And the minimum east front yard setback is also listed at 50 feet. We're proposing a change to reflect the 10-foot setback that was previously approved. Through this petition, we are asking for a minimum southern side yard setback of 20 feet. That is correctly listed here in the condition. Condition number 5 discusses buffer areas. And I thought the way this condition was written was somewhat confusing because we have such odd-shaped parcels. So what I would like to do is make it very clear that a 10-foot wide buffer with type B screening shall be provided along the southern boundary of the special use permit area located on the southern side yard of Lynn Road within the southern yard setback. And I want that clarification because when looking at the site plan, there are 2 southern boundaries because of the odd shape of this southernmost parcel.
So let's make sure I got that right. Just one second. Condition number 5.
Okay.
10-foot wide, and I'm at condition number 5, type A screening. And what's confusing about the way it's written, or what's not quite accurate?
I didn't think that it read clearly that there is 2 southern side yards. So what I want to say, this is a rear yard here. This is a side yard here. So I just wanted to make that clarification that the type B buffering is required in that southern side yard.
Okay.
And
10-foot wide buffer with type B screening provided along the southern boundary of the special use permit area. That's the part.
Yes, ma'am. And then finally, the increased fence height was intended to be along both Lynn Road and Williams Road. To be fair, I could have been more clear with that in the write-up. I do think that I hit on that when I said along the perimeter of the parcel, but what we're asking for is the condition to read sentence number 1, the parking area contained in the special use permit area on the south side of Lynn Road shall be I'm sorry, may I start again? What I'd like for it to say is the special use permit area on the south side of Lynn Road shall be provided with a 6-foot high metal picket fence along the Lynn Road and Williams Road frontages.
Which condition are you looking at?
Condition number 9.
9, okay. Okay.
And the justification here is that we feel that a 6-foot tall fence surrounding the property, the property will direct people to the appropriate pedestrian crossing. The approved special use did not allow or did not require a fence along this Williams Road frontage. It was assumed that a 4-foot fence would be allowed because 4 foot is the maximum height of the front yard fences. We do feel that 6-foot high would, just really direct people to the appropriate crossing location.
So since these are not reflected in the staff report conditions, is the applicant proposing these condition changes at this time?
Well, condition number 3 was a scrivener's error. Okay, so that one just kind of goes that way. Condition number 5 will, in my opinion, read more clearly to direct the reviewer where that type B buffer will go.
Okay.
And condition number 9 kind of is a companion to that additional variance we requested for the increased front yard fence height, because this is the southern parcel is a corner lot.
Was that was the fence height, condition 9, was that addressed in your application? Did staff review that, or is that something new this morning?
I think maybe the answer is, I believe it was in the staff report because on my narrative, because on page, I think it's page 6 of my staff report, I addressed the fence height request, and I include a sentence that says, as proposed, the fencing will be metal picket style connected to brick columns and extend along the perimeter of both parcels. So I think that was something that staff did not clearly pick up on. And then in the variance criteria, I speak to that, but in hindsight, the devil's in the details. I can see where that wasn't picked up by staff.
All right. I think I'll have to have Development Services address that when it
Sounds good.
comes to that.
That concludes my presentation. If you have any questions, I'd be happy to answer them.
Okay. Well, first of all, this special use application, and I understand there were prior variances granted.
Yes, ma'am.
And I will look at that. Can you address, for the purpose of variances, the hardship criteria? And I know there are 6.
There are 6 of them, and in my report, I included a pretty detailed response to that.
To each one?
To each one individually.
Okay, good.
Okay.
Thank you.
Thank you.
All right. Development Services, please.
Before Tim starts his presentation, Patricia, just so I have a better exact understanding of the change you want in condition 5 regarding, the condition right now says a 10-foot wide buffer with type B screening shall be located along the southern boundary of the southern parcel, right? And what is it that, you're looking to do? Because
Okay. The last sentence of that condition number 5 does not specifically say which southern boundary that 10-foot B buffer is required in. And on the site plan, it's clear that it is in this southern side yard. So my intent is to ensure that a type B buffer would not be required down here near the stormwater pond.
Okay, so because by code, the entire south boundary of this property is a side yard. Being a corner lot, you got 2 front yards and 2 side yards. So what you want to exclude then is simply, except, I think way to phrase that would leave it as it is, say, except where adjacent to the south end of the stormwater pond. Is that
would work?
Consistent? Yeah, I mean, that provides clarity as to what you're requesting, right? And indeed, the site plan doesn't show it on the south side of the stormwater pond. So 10.5, condition 5 says a 10-foot wide buffer of type B screening shall be provided along the southern boundary of the special use permit area located on the south side of Lynn Road, except that no buffer or screening shall be required on the south end of the stormwater pond. Is that consistent with what you want or what you're proposing?
Well, to be honest, a 10-foot wide type B buffer is required in this most southern side yard here. This is a 10-foot A over here.
The variances you're asking for. I mean, first of all, I just want to have an understanding of where you think the 10-foot, right now the condition is the entire south, including the south end of the stormwater pond is under the condition. What is it you're requesting to eliminate?
Okay, this condition carried over from the previous special use. And I just want to clarify that the only area that type B buffering is required is right here.
Oh, well, that's absolutely not correct as far as that condition as written and carried over from the past is the entire south boundary. There's not, the condition as written never contemplated, and in fact, on the site plan, you can see it even labeled coming down the east side of the stormwater pond. I don't see that to be a clarification, and I don't know that it was something that was addressed in your application either.
The site plan currently says 10-foot type A buffer. So it's the B buffer that I'm concerned about being confused.
Oh, okay. All right. Oh, I see. The 10-foot wide buffer with type A screening shall be provided on the west south. Okay. Okay.
Yeah, I'm just trying to be sure we all know where that B buffer goes.
Yeah. Okay. And now I see if you take the second sentence and the third sentence together. Okay. How about we just say the last sentence, a 10-foot wide buffer with type B screening shall be provided along the remainder of the southern boundary, because the sentence prior to that says where you have the type A buffer around the stormwater pond. So we'll just insert the word remainder.
Yes, I'd be fine with that too. And I am glad we're having this dialogue because it is confusing to.
Yeah, no, you're correct. And in reading the entire condition now, I see that it has always called out certain screening around the pond and then a different screening. Yeah, I believe inserting the word remainder in that last sentence will clarify what is the existing requirement when you took the two sentences and look at the site plan. That is correct. So that's a good clarification. Yep.
Thank you.
Okay. All right. So Tim, if you want to make your presentation, please.
All righty. So this was recently approved in 2019. It was special use approval SU 19-0834. It was approved for the Hindu temple on the property located on the north and south sides of Lynn Road in the proximity of Williams Road. Approval of a waiver was granted allowing a church with more than 300 seats to be located on a local road instead of an arterial or collector roadway as required by Land Development Code section 6.11.25.c. The present special use request seeks changes to the existing approval. Per LDC section, I'm kind of repeating a bit, 10.02.03.j, the request is to modify existing conditions in the site plan for an approved special use that then must follow the same review process as a new application. As we were just discussing, condition 5 was brought over from the previous approval. The applicant is required to once again request the waiver and site development variances that were previously requested and approved. Additionally, the applicant is requesting a variance to allow 6-foot fence in the front yard. In the application's submittal, they did request a variance of the front yard. However, it didn't detail Williams and Lynn Road, but however, both Williams and Lynn Road are front yards. So the variance would apply to the required front yards on both Williams and Lynn Road. The surrounding area is primarily residential in character with the presence of residential support uses, including schools and churches. The Hindu Temple of Florida has existed at 5509 Lynn Road since 2000 and currently consists of 3 buildings. The Hindu Temple of Florida is seeking to expand their site, as the applicant explained, with the inclusion of the 1.03 acres located on the south side of Lynn Road, at the southeast corner of Lynn and Williams Road. The multi-purpose building will consist of 21,531 square feet, which is an increase of 4,741 square feet, more than the 16,790 square feet that were approved as part of the special use 19-0834. Per section 6.11.25.c, churches must have direct access to arterial or collector roadways if a seating capacity exceeds more than 300. This is the reason for the waiver request, why they're required to have it. There are a number of requested variances. I'll go through them quickly. All of them, but the last variance were part of the initial application in 2019. Variance 1 is regarding LDC section 6.01.01, and it's to allow a 20-foot north front setback on folio 23824.0000 fronting on Lynn Road. This variance request, variance 1, was previously approved by SU 19-0834. Variance number 2, per LDC section 6.05.02, is a request to allow a 10-foot east front yard setback, folio 23824, fronting Williams Road. Variance 3, LDC section 6.05.02.D.2.E is regarding off-site parking shall occur only in industrial, commercial, and office districts. The provision of the required parking on a non-contiguous portion of the special use permit area is permitted if the criteria found within 6.05.02.D.2 is met. This requested variance number 3 was also previously approved with SU 19-0834, as is the following variance 4, which is LDC section 6.05.02.D.2.B, which is requesting a variance to increase the walking distance by 190 feet, resulting in a walking distance of 490 feet between the off-site parking area and the temple's eastern building entrance, which is shown on figure 4. Variance 5, per LDC section 6.05.02, a minimum of 142 spaces is required. The applicant requests a reduction of 38 spaces, resulting in 104 spaces. This request was previously also approved with SU 19-0834. Come to variance 6, which is a new request. It's per LDC section 6.07.02.C. Fences over 4 feet in the front yard are not allowed. The applicant requested 2 feet in the front yard fence height, resulting in a 6-foot front yard fence for folio 23824.0000 south side of Lynn Road, and 23779.0100, the north side of Lynn Road. Staff finds the waiver request. Staff is not making a recommendation on the variances, but finds the waiver request approvable, subject to the conditions. The applicant did reach out to staff prior to the meeting and concurs with the proposed modifications. That concludes staff's presentation, unless there are any additional questions.
Don't have any questions for you, Mr. Lamkin. Thank you.
Thank you.
All right, Planning Commission.
Hi again, this is Jillian Massey with Planning Commission staff. The subject property is in the residential 4 future land use category. It's in the urban service area and located within the limits of the Greater Carrollwood-Northdale Community Plan. The proposed special use is a resident support use and compatible with the surrounding development, which includes a number of places of worship, such as churches. Support uses are allowed in all residential future land use categories, including in this case, the residential 4. The applicant is proposing 41,100 square feet total over the entire site, with an acreage of 3.77 acres site. The request will be developed at a 0.249 FAR, which is within the 0.25 maximum of what can be considered on the site. Churches, schools, daycare centers are defined as residential support uses by the Comprehensive Plan, Policy 17.1, and are allowable in the future land use categories as long as their intensity and design are compatible with the surrounding land uses. The proposed use is compatible with the surrounding single-family detached residential uses and existing residential support uses in the vicinity. The community design component, or the CDC, in the future land use element of the comprehensive plan contains policy direction about designing developments that relate to the predominant character of the surroundings. It further states that new developments should recognize the existing community and be designed in a way that is compatible with the established character of an area. There are existing residential support uses in the area, such as daycare, schools, and other places of worship, such as churches on the north side of Lynn Road. The stormwater pond in the southern parcel will provide a natural buffer to the single-family residential to the south. The proposed special use also provides a pedestrian crossing that would link the existing temple to the proposed multi-purpose building on the south side of Lynn Road. This fulfills the intent of Goal 15 of the CDC. The Greater Carrollwood-Northdale Communities Plan supports development and redevelopment that ensures that development is integrated with the existing suburban nature of each neighborhood. The applicant has proposed measures to mitigate impacts to the surrounding development pattern. The applicant is providing a pedestrian connection across Lynn Road and additional bicycle parking on the site, demonstrating connectivity with the site and the surrounding area. Moreover, this special use application is in tandem with the plans for the temple to upgrade the architectural exterior features of the site to provide greater aesthetic appeal. And based upon those considerations, the Planning Commission staff finds this proposed special use consistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County, subject to the conditions proposed by Development Services Department. And that concludes my report if you have any questions.
Thank you. All right, we'll move on to proponents. Are there anyone here or online who wishes to speak in support of this application? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? Okay, don't hear anyone. All right, Development Services, anything further?
No, ma'am.
Okay, applicant.
Just a couple things. I'd just like to let you know that in the audience, I have the former president of the board of directors, Dr. Babu, the construction manager, Mr. Ganga, and our construction project manager, Oscar Bienvidez. And I have 2 letters of support in this packet of information that I'll be giving to you, along with 4 copies of the proposed changes to conditions of approval.
Okay, wonderful. Thank you.
Yeah, thank you so much.
All right. That will then close the hearing on application 21-1333.
Our next case is item J3, special use application 21-1374. The applicant is Shaughnessy Dobish. The request is for a 2 COP alcoholic beverage permit, which requires separation waivers. Staff report and recommendation will be presented by Tim Lampkin following the applicant's presentation. For this special use and the next one, Planning Commission staff does not render comment on alcoholic beverage request.
Thank you, Mr. Hisney. All right, applicant.
Good afternoon. My name is Terry Haley, 108 Clock Tower Drive, number 157, Brandon, 33510. I'm going to start thinking this personal. I'm always the last person in the building, so I don't know if I've done something or what. But no, to talk about the request here, my client is requesting a 2 COP to operate in conjunction with a small cafe they're wanting to include in their building. They are a home decor store, which is located basically in the middle of nowhere. And they're revamping their program. One is they're going to include some in-house interior decorators, and the idea of adding the cafe along with the beer and wine is that it may keep a customer there longer, in the sense that an indecisive customer might want to, hey, we're going to go grab some lunch. Well, that's 10 miles away and you might lose them. So it's an amenity adding to the store. Of the requirements, we do meet the distance requirement of residential. There is no residential, and also of community uses. We do request this waiver for a distance waiver from a community use, which is actually Pinecrest Elementary School. And the requirement is that it be 500 feet. In looking at our measurements, our to the school property from our zone premise or requested premise is only about 160 feet to their property line. However, if you extend it to the building, it's a little over 500, around 517. And we want to mention there that just in order to do this, there are some buffers. One located on both sides, what would that be, east and west side of Highway 39. There are drainage ditches you must cross. You must cross Highway 39, which is a busy highway in that area of the county. Then you approach a 4-foot fence one would have to climb. And then you're on the property. And then, like I say, then there's parking lot on the other remainder of, say, 330 feet to the building. And then a couple other ways to look at it. If you look at if one was to walk legally using the crosswalks and sidewalks provided and stuff, yeah, you're looking about, I think it's, let me see, I have it here. As luck would have it. It's actually right around 1,600 feet. And then via car to accommodate their provided entrances and exits from both establishments, you're looking a little over, it's around 620 feet. Okay. I do know when he presents it, Mr. Lampkin, along with staff, has come up with some conditions. Just to go ahead and let you know, we have no problem with those. And primarily, I think those fall into, in order to secure the zoning and maintain it, the store must operate as a home decor store, which we have no problem with that. And it is a limited hour venue. Our times of operation are roughly 11 a.m. in the morning to 7 p.m., 7 days a week. And I can say the business itself has been there, get my track here, about 5 years. And they're pretty much a silent entity as far as the school and communities involved. But we are seeking this waiver to, again, enhance and improve on a independently owned business in Hillsborough County.
Okay, thank you. Be sure and sign in with the clerks.
Okay.
All right, development services.
Hello, Tim Lampkin, Development Services, case SU-AB 21-1374. The request is per section 6.11.11 for a distance separation waiver for 2 COP alcoholic beverage permit. The applicant meets all the distance separations except the applicant does not meet the distance from the proposed structure to the community uses, which shall be over 500 feet. And the proposed wet zoning is approximately 160 feet from Pinecrest Elementary School. Per LDC section 61111.E, waivers to the required separation distances may be requested by the applicants at this hearing. The applicant requests a 340-foot waiver to the required 500-foot separation to allow a separation of 160 feet. The applicant's justification for the waiver includes a number of issues that they went over. For example, the buffering, the drainage ditch, a fence, county road, there's no crosswalk in the middle of it, second drainage ditch. And staff finds that per section 6.11.11.E.3, it provides for approval of separation waivers where there are special or unique circumstances. The Pinecrest Elementary School, while it is approximately 160 feet from the proposed wet zoning structure, however, as the crow flies, it's this distance. However, as the car goes, it's approximately 620 feet. And as a pedestrian, it would be approximately 1,600 feet if you go up to the nearest crosswalk. The school district staff objects to the proposed zoning on the grounds that it does not meet the distance required separations from Pinecrest Elementary School. However, school staff objects to all requested separation waivers from schools and provides no basis for the objection other than the lack of required separation. In the subject case, staff finds that the circumstances discussed above and the proposed conditions mitigate the need for the required separation distance. The proposed zoning is requested by an established home decor business seeking to expand their business model to provide their clientele alcoholic beverages. The applicant, as they just stated on the record, has agreed to a condition limiting the use of the wet zoning to a home decor store and to limit the sale and consumption of alcoholic beverages to certain hours. For all these reasons, staff does find the proposed wet zoning does not pose significant impacts on the school and surrounding land uses, and the necessity for the specified distance requirements is negated. Staff finds the proposed 2 COP permit to be approvable subject to the following condition. Approval is based upon the revised wet zone survey, reflecting a total zone footprint of 6,052 feet as shown on the survey received on October the 13th, 2021. The condition is the permitted alcoholic beverage use shall be accessory to a home decor store, period. The sale and on-premises consumption of alcoholic beverages shall be limited to the hours of 11 a.m. and 7 p.m. daily, period. That concludes staff's presentation, unless there are any questions.
Thank you, Mr. Lamkin. All right, is there anyone here or online who wishes to speak as a proponent in support of this application? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? Do not hear anyone. Any further comments from Development Services?
No, ma'am.
All right, applicant, anything further? All right, nothing further from the applicant. That will close the hearing then on special use 21-1374.
Okay, our last case today is item J4, application SU 22-0081. The applicant is UBC Bikes Incorporated, and the request is for a 2 COPX alcoholic beverage permit. The agenda is incorrect. It does not require separation waivers. How it does require approval of the land use hearing officer for reasons that will be explained by staff following the applicant's presentation.
All right, thank you, applicant.
Again, Terry Haley, 108 Clock Tower Drive, number 157, Brandon, Florida. I am representing UBC Bikes, Inc., who is a concessionaire, holding a lease and approval for their business within the Alafaya River State Park. Their business is a satellite store of UBC Bikes, which actually stands for University Bike Center, of which their main store they've operated since the 70s. And what they do with this satellite store within the park is the park does offer trails. You can't really say much of mountain trails, but mountain bike trails for those enthusiasts. Until now, they've offered the rental, the sign up, supplies, snacks, just a small food concession to those guests of the trails. Mentioned a little bit previously is that all requirements are met, meaning distance requirements of residential, also community services, and if any other licenses or anything that involve. But however, in this case, there is a special zoning requirement that any hearings within this state property or these areas like this to the public must be heard by the land officer. So that's why we're here. Again, we meet the requirements because if anyone were to be notified, it would be notifying themselves. But they are a small dot within the park. Their area, as shown on our survey, will be well-defined with including fencing, posted signage, and some is naturally defined with a couple creeks and canals. As far as the sales of the alcohol, it is limited to the patrons of the bike shop. It is carrying an X qualifier meaning that there are no package sales. It's only consumption on the premise. And also, due to the limited hours of the park itself, we are also doing limited hours of consumption. Basically, it is 10 a.m. till 7, 6 days a week, and moving that, to be legal on Sundays to 11 a.m. to 7. And if it means anything also, you probably wouldn't see one like me riding those trails. So typically it's a healthier, more health conscious person. So as far as the alcohol sales, I think it would, involve a lot of the low carb beverages, some of the natural stuff, some of the craft beer stuff. It's not an offering just to have a field day in the park drinking. So if there's any other questions, I'll be glad to get them now or later, but it's pretty self-explanatory.
Got it. Understand. Thank you. I have no questions for you. All right. Development Services.
Hello again. Tim Lampkin, Development Services for AB 22-0081. So per section 6.11.11, the request is for a 2 COPX alcoholic beverage permit to allow the sale and on-premise consumption of beer and wine in connection with a bicycle concession in the Alafaya River State Park. The property is zoned agricultural mining, which permits the proposed use and consideration. Pursuant to Land Development Code 6.11.11.A.1, alcoholic beverage permits that are requested for agriculturally zoned properties require special use approval regardless of whether the requested permit meets applicable separation requirements. So essentially, as the applicant stated, they would be requesting a separation distance for the community use the park from themselves. In such cases, the LUHO shall be required to make a finding of general compatibility with existing zonings and uses in the area, and the permit shall be conditioned to limit the sales and or consumption of alcoholic beverages to the specifically identified host. So the proposed wet zoning is sought for a bicycle concession located in the Alafaya River State Park. Per the revised survey received on November 5th, 2021, the proposed wet zoning will comprise approximately 59,765 square feet of area, of which 2,943 square feet will be enclosed or covered. Staff finds that the applicant has proposed the following hours operation for the alcoholic beverage use, which is also in compliance with the Hillsborough County hours of operation for alcoholic beverage use, which is 10 a.m. to 7 p.m. Monday through Saturday and 11 a.m. to 7 p.m. on Sunday. These hours are substantially more restrictive than those permitted by the LDC, which would be Monday through Saturday, 7 a.m. to 3 a.m. and Sunday, 11 a.m. to 3 a.m. The wet zone boundary will be accessory to a bicycle concession that is located a substantial distance from the exterior boundaries of the host park, which is approximately 6,300 acres in size. Due to its location, the wet zoning poses no nuisance impacts to uses outside of the park. And there is a map showing the approximate location, which is approximately 2,500 feet from South County Road 39 in Lithia. For the reasons discussed above, staff finds the proposed wet zoning approvable subject to the recommended conditions. Approval is based upon the wet zone survey reflecting the total wet print foot area of 59,765 square feet as shown on the revised site plan. Stamped received November the 5th. Those conditions there are three. The first one is the alcoholic beverage use shall be accessory to the operation of the bicycle concession. Number two is the sale. It's regarding the hours. And number 3 is the boundary of the wet zone area shall be largely defined by vegetation, natural features, fences, or other similar measures. Additionally, signs shall be installed at unobstructed areas of passage across the boundary stating, quote, no alcoholic beverages past this point, unquote. A sign shall also be posted at the point of sale at the alcoholic beverages stating, quote, no alcoholic beverages outside of the concession area, unquote. And those are provided because there's some open space. It is highly vegetated. And if you look at an aerial or go there in person, you'll see that it's hemmed off on one side by a stream, which would need signs so people understand that the stream is a boundary and where the woods begin, and other areas it may be fenced. And that concludes staff's presentation, unless there are any questions.
Don't have any questions for you. Thank you. All right. Are there any persons here or online who wish to speak in support of this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right. Do not hear anyone. Anything further from the Development Services?
Nothing further.
All right. Applicant?
Yeah, probably not necessary, but something I did want to bring up that overall, it seems like an unusual request, but over a dozen of these have already been issued throughout the state, and one actually being here in Hillsborough County with Hillsborough River State Park. So it's not as unique on government property as you would think. And we do have permission both from local park management as well as their higher ups in Tallahassee.
Okay. All right. Thank you. All right. That will close the hearing then on special use 22-0081. And that will conclude today's Land Use Hearing Officer meeting. Tired of sitting?